Hey everyone, it's me again, Jason. Thanks for joining me. Let's finish up opinions by talking about the actual law. Alrighty, so here's our outline for the second part of week 7. Talk about the distinction between opinion and fact, the rules for admitting lay opinion evidence, and the rules for admitting expert opinion evidence, including the procedures for the third one there. Alrighty, here are the rules. They follow a similar structure that we're used to: exclusionary rule and then exceptions. Section 76 is the exclusionary rule. 78 and 79 are the exceptions. 78, the exception for lay opinion. 79, the exception for expert opinion, or as the Act calls it, opinions based on specialized knowledge. We'll start with the rule for lay opinion. The rule says that the opinion rule does not apply if the evidence is based on opinions about what the person saw, heard, or otherwise perceived about a matter or event, and that it's necessary to explain the perception of the matter or event. Just for other references, the Section 108C, which is under the credibility section, you might recall, is the exception for expert witnesses who give evidence about the credibility of another witness or some other evidence. This is often the case with an expert who gives evidence about a child witness, perhaps explaining that it's not uncommon for a child witness to have not reported something early on. That doesn't necessarily mean that they're lying now. And that rule pretty much just has the same foundations as Section 79, but it adds the additional component that the evidence must substantially affect the credibility of other evidence. And then, as we'll discuss, Sections 135, 136, 137, another basis for excluding any evidence, including possibly, but rarely, opinion evidence. So let's start with the distinction between opinion evidence and fact evidence. This is a notoriously tricky area, as the ALRC says here. It's a distinction that is difficult to draw, but it's helpful. And in many cases, the common law has just figured it out. And we have these certain categories that we know certain evidence fits into. So they decided to not do away with this distinction. As to what is opinion, it is not defined in the Uniform Evidence Act. However, it's been defined. There's a rather common definition that we see in both of the required cases for this week, Honeysett and Lithgow, both high court cases, which say that it's an inference based on observed and communicable data. You might recall this definition actually from Kirby's dissent in Smith, which we looked at in the case of relevance, in which he departed with the rest of the court and said the evidence of the two police officers who didn't actually observe the crime, but looked at photographs later and compared those to their memories of the person, were giving opinion evidence. That was partially because this was evidence that was more susceptible to judgment and disagreement. It was an inference based on what they had seen or alleged to have saw. So let's talk about the lay opinion exception in the context of Lithgow. Lithgow is a case in which Jackson sued Lithgow City Council because he said there was some unmarked land that he fell from and injured himself. And the question was, did he fall from the area that had the lack of signage? I think there's a nice little quote here. I normally don't like when judges get too cute with their writing, but there's a nice quote here about the fidelity of dogs, which I like. I'm a cat guy, as everybody knows, but I can still appreciate it. And the potential opinion evidence was in the form of a note that was written by the ambulance drivers. It said, found by bystanders, parkland, fall from 1.5 meters onto concrete, no other history. And these drivers were not called as witnesses. This was important to indicate where he fell from, where Jackson fell from. Lots of issues in this case. We won't get into all of them. Usefully, it gives a bit of a background on the lay opinion exception the High Court gives here. It says this is a rule that comes out of necessity. Sometimes it's just easier to express something as an opinion, but the rationale is one of necessity. The classic example is a person appeared drunk. So it's just easier to say the person seemed drunk than to try to explain all the small reasons why you might think that. Another is, the car seemed to be going about 60 kilometers per hour. You could try to explain all of the facts that go into that. However, it's just more convenient to provide this in the form of an opinion. So we allow that in certain cases. It's called sometimes a compendious statement of fact. The restrictions on it, though, the High Court found subsection A and B were not made out. Somewhat unusual facts in that in most cases, in a lot of cases, you're not going to see these opinions in the form of these handwritten notes to actually have the actual witness there so they can explain what they were seeing. But here in this note, we don't really know if anybody actually saw this fall, if there was any actual person who observed this matter or event. We don't know if the ambulance drivers were providing their opinion or the opinion of somebody else. It was just very unclear. So there just wasn't the evidence to know that this was an opinion based on what somebody saw, heard, or otherwise perceived about the matter or event. We really just saw the aftermath of it. You can actually draw an analogy here to the reason Justice Kirby said that the police officer evidence was not permissible in Smith. The police officers did not have personal knowledge of the bank robbery. They weren't there. They were just looking at this CCTV image of the aftermath. So that in neither case could the party that was proffering the evidence demonstrate that there was personal knowledge. And the High Court said it would also fail the necessity exception here. It seems like, the necessity requirement. It seems like the only reason that this was provided in the form of this handwritten note wasn't because it was easier to express it that way, but just because that was the form it came in. So it wasn't necessary. So I suppose the person who actually wrote this note could have written it out in a more thorough way. There wasn't a necessity to explain this event in a certain way. So that's opinion evidence. Let's move on to the issue of expert evidence. If you recall, and hopefully you do because the video just happened, there are some concerns with expert opinion evidence in the literature and in reports from like National Academies of Sciences, things like that. And we might think to ourselves, are these rules well designed to address those concerns. So here's the rule. It's in section 79. It seems to have two general components. First, there's an exception. If a person has specialized knowledge based on that person's training, study, or experience. So there seems to be two parts of that. There has to be a field of specialized knowledge, and the person has to be qualified in that based on their training, study, or experience. So a field, qualifications, and the second part is that the opinion is actually based on that. So you're not stepping outside of your expertise. And we'll see that is violated in Honeysett. Sometimes that latter part is called the basis rule. So let's focus for a second on specialized knowledge. Many people have argued that that term specialized knowledge shouldn't just mean an organized field, like some field of which there is textbooks and journal articles and conferences, but that this field is actually demonstrated empirically or otherwise that what they do has some degree of accuracy or reliability. As you can imagine, the field of astrology, lots of books written about it, but most of us would say that that shouldn't be evidence in court. So we see some beginnings of a definition of specialized knowledge here in HG, Justice Gaudron saying, it's a field which is sufficiently organized, and then says that it's recognized to be accepted as a reliable body of knowledge. So this suggests reliability might be part of the definition. And we'll see some pushback on that in Tang. Tang's a New South Wales Court of Criminal Appeal case. It was an expert witness who had qualifications in what is sometimes called face mapping. She claims to be able to compare two photographs of faces, look at the features of them, and say if they are the same person. That's not what she was doing in this case. She was trying to extend that into what she called body mapping. So applying the same principles to just comparing two people's bodies, body in CCTV images to the body of the accused. The court here says, okay, we're pretty convinced that face mapping, face identification, is specialized knowledge. However, you haven't shown us that there is this organized field of body mapping, and we're not really convinced that there is. So it's going to fail there. That's where it fails. However, we're very clear to say that the idea of reliability is extraneous to this calculus. Reliability does not go into whether or not this is a field of specialized knowledge. So again, seems like you can have all the trappings, you can get around this rule by having all the trappings of an organized field, when in fact you're just creating snake oil. And for a lot of commentators, that's a problem with this ruling. Is revisited to some extent in Honeysett, 2014. Here, this is the actual CCTV image that was in question. Here, the expert was very careful to not use the term body mapping because the law is based on precedent, and Tang seemed to, at least in some ways, look down on body mapping. He was a man who was a professor of anatomy at Adelaide, the expert, and he said that he could look at Honeysett and this CCTV image and say that he didn't say it's the same person, but he said, I can't see any differences, which you might think is a pretty strong statement. A lot of the things he said were a little absurd. So he kind of used very technical language for very simple things, using the term lumbar lordosis, which just means a well-bent small of his back that overhung by the shoulder area. He said that his hair was short, which it just seems like you study anatomy, my guy. It's not clear to me that that qualifies you to look at the balaclava someone's wearing and determine if their hair is short under that. That's more of a hat maker's job, right? It's a lot of problematic things with this. I think the High Court wants to exclude it, but they don't want to do it on reliability grounds. And that was a large part of the challenge that, hey, Australia, High Court of Australia, we need a reliability rule. We don't have one. Canada has one. US has one. We should have one. This is a great case to establish that. So that was the challenge. The High Court sidesteps the reliability issue. And they say, okay, expert, Professor Henneberg, you clearly have expertise. You clearly have specialized knowledge in anatomy, but you have to explain to us how doing this identification or quasi-identification task is actually based on anatomy, because you didn't make that clear. There's a violation of the basis rule that I talked about earlier. Your opinion was not based wholly or substantially on your specialized knowledge, as you've led us to think. So I'll touch more on the basis rule in a second. Let's finish up this idea of reliability. Clearly, the High Court does not want to get into that, at least not in 2014, maybe in the future. Can reliability go into the lack of probative value of the evidence? The leading case on this, which, as I'll talk about in the discretions class in week 8, seems to have been overruled. Not expressly, but it's hard to understand how it wouldn't have been based on the language in this case, IMM. The case is Toot. And Toot, you can read it through my slides. I don't want to spend too much time on it. It says, okay, we agree that Section 79 doesn't say reliability. However, we do think that reliability is a part of probative value. And it did lots of things that lots of commentators liked, citing some academic research, cites the National Academy of Sciences study, the National Academy of Sciences research that I mentioned earlier, finding that all these problems with forensic science. And it says that reliability, the lack of demonstrated reliability of expert evidence can reduce its probative value for Section 135 through 137 and could be a reason to exclude it. Again, I think that's probably not good law anymore. How about the unfair prejudice part of the 135, 137 calculus? There's not much to go on here. At least 2 courts that I know of, Wise and Polino, have said that one source of prejudice that militates towards exclusion is what's called the CSI effect. The funny thing is there actually isn't much evidence for a CSI effect, as mentioned in that Schauer and Spellman article. I mentioned the latter in part 1. I think the bigger concern is lots of expertise isn't reliable, but these courts don't like to do that. But what they will do is say there's this risk of overvaluation, risk of people thinking that all of CSI is like the TV show, and that constitutes prejudice. So we saw evidence excluded in Paulino for that reason, and at least referenced favorably and more recently in Ramirez. Let's talk a little bit more about the basis rule pretty quickly. I have most of these excerpts. I'm going to go pretty quickly through this because I'm alive to the fact that I went a bit long in the last one, and I'm also alive to the fact that I made loud drinking sounds that I can't delete now. So please forgive me for that. So at common law, there was a rather thorough and onerous basis rule, which required you to, the expert witness to identify all the assumptions they made, state all of the reasoning between their opinion, the facts, and their assumptions, and prove all the facts they're relying on. So if you are using the report of somebody else to actually have that report in there, have the other witness give that report, things like that. There's a question then of if this survived the uniform evidence law, or if it's just in that statement that second part of section 79, which is that the opinion you're giving is based on your specialized knowledge, which is a very sort of general, not clearly very onerous basis rule. So we'll see this play out in several cases, starting with HG and Das Reef, and in several cases that followed from that. So in HG, I won't get into the facts, but Justice Gaudron says, okay, there are these matters like explaining your reasoning, identifying all the facts you're relying on, but these don't go to admissibility anymore. If you fail to do any of these, unless it's really serious, this goes to weight. Tasrif, I won't get into the facts here as well. You can read this on the slides. There was a dissent. One judge dissented, saying that the basis rule still exists. It goes in a long history. I think it's a longer dissent than the actual judgment. But the rest of the court doesn't really seem to agree with that. And I'll focus on that sort of final long highlighted part. That a specialist medical practitioner expressing a diagnostic opinion in his or her relevant field of specialization is applying specialized knowledge based on his or her training, study, or experience, being an opinion wholly or substantially based on that, will require little explicit articulation or amplification once the witness has described his or her qualifications or experience. Seems to just be saying here that in most cases you can just say, I'm an expert in this, here's my opinion. Don't really have to explain all the steps in between. And failure to do so is not a matter of admissibility. This comes up in this case, Kai Luck. It's a question of whether Kai Luck picked these plants from some protected part of New South Wales. The expert is someone named Tu Lau. Looks at the soil in the found plants, looks at the soil in the protected lands, finds some similarities. But the problem is Tu Lau is relying on this particle size test that compares the particle size of the soil that was not actually in evidence. It was just referenced by him, and it wasn't conducted by him. It was referenced by somebody. It was conducted by somebody else. So several issues here. One is this is a violation of the expert witness code of conduct. Is it a violation of the basis rule, or is it excludable under section 135? So Justice Price's judgment, which is the lead judgment, says, okay, so breaches of the code of conduct, which I'll get into in a second, do not require exclusion. So just because you didn't follow the expert witness code of conduct, which is in the Supreme Court rules and the Uniform Civil Procedure rules, does not require exclusion, but Price would exclude it under section 135. And you can also see this is clearly, this would, if this was the common law basis rule, it would seem to be excluded here because Tu Lau didn't prove the basis of the opinion. But it wasn't excluded under those grounds. It just said that this would be very prejudiced. This is important evidence, and it would be very prejudicial because you can't actually cross-examine it in this case. So you can imagine other cases in which the evidence isn't as isn't as important to the evidence. It wouldn't be excluded under 135, but here it was. Schmidt would actually exclude this for basis reason rules, and McCallum follows Price. The soil analysis wasn't enough to call this a violation of the basis rule. As we saw in Dust Reef, the basis rule is pretty light. You just have to say that this opinion is based on my training, study, or experience. Langford I won't really get into, but you might use this to juxtapose this with Kyluk, because here is a similar problem. Some of the analysis was done by somebody else, but here it wasn't excluded under 135. It wasn't excluded as under the basis rule, and the main difference seems to be that this extraneous opinion that Catterall, the expert, was relying on just wasn't as central to his opinion as was the case in Kyluk. So you can read my excerpts here. I have the slides up on the canvas, but I don't want to belabor these points. So basis rule seems like those original three things tend to go to weight unless it rises to quite an extreme level, such that it wasn't your opinion. So we've gone over the law. Let's very quickly, and I will make parts 3 and 4 shorter. So don't worry, I'll stay under the 2 hours or hour and 15 minutes. Total identification evidence is a little more straightforward and a little less juicy, if you will. So procedure is interesting. We have some procedures to help control expert witnesses because of all these concerns that we have. One of them is the court has the power to appoint a witness. So this is clearly avoiding the adversarial concerns. This is clearly in reaction to the adversarial concerns that we had, because we have the court appointing the witness and not the parties. We're taking it out of the adversarial system. There are some rules for joint experts. Generally, I generally use this term to include lots of reforms, like the idea of hot tubbing, so having 2 experts give evidence simultaneously. And there's the procedural reform of codes of conduct, which I'll spend a bit more time talking about now. So if you're interested in these rules, you can find them in these places. This says uniform civil procedure rules, but they have been ported over to criminal matters via the Supreme Court rules, Division 1, Section 3J, and if it's in the district court Section 171D. And so what does a code of conduct look like? It starts off with now the expert is supposed to read this and sign at the bottom, but it says, okay, expert, you have to know that your duties to the court, not to the parties. And then it gives some more specific examples of that or expressions of that, saying that expert, you must disclose all of the examinations, tests, or other investigations that you're relying on. You must declare that you've done all the inquiries that you think are desirable and appropriate. Express any qualifications that you think are important. My main problem with this is there's lots of wiggle room. There's lots of ways. You can imagine an expert who is influenced by the adversarial system, wants to come to a certain opinion for lots of reasons, maybe because of that sweet Skrilla, and says, oh yeah, I believe that I've done everything desirable. Actually, I think it should be more of an objective test, more of an objective code of conduct is my main criticism with this. These flowed from a UK case called Icarian Reefer. Courts were very concerned in the early 2000s about bias. Lots of language about how these would solve all of the problems. And we might be mainly interested in is how does non-compliance with the code of conduct impact the admissibility of their opinion. So it used to be when these codes first came out that courts would actually police this and actually exclude evidence if it didn't follow, if the expert hadn't acknowledged the code of conduct or hadn't read it. Later, it became more just a matter for Section 135 or 137, and as we saw, a really sort of grave breach of the code of conduct in Kyluk led to the exclusion. But it seems like, as in Wood, and if you recall, Wood was the Rod Cross case, the Court of Appeal says here it must be a sufficiently grave breach. What does that mean? Not that clear. There might be a very grave breach in Chen. I think one of the gravest that you'll possibly see. It was a translator who was actually part of the investigatory team with the police. So usually we want expert witnesses to not be involved in the actual investigation. They're just there for the court proceedings, the adjudication. This one also said things that were later turned out to be untrue. She said that she had learned certain languages in certain places she hadn't learned. So very problematic one. Actually did not even know about the code of conduct until the day that she went to court. So normally the code of conduct is supposed to be given to somebody before they prepare their expert opinion and report, because that's the point of it. If you just show it to them afterwards, they'll probably just say, "Oh yeah, I would have come to the same conclusion had I known that." Nobody can really do the mental gymnastics required to put themselves in the position that they would be in before they came to their opinion. But despite all of those things, the court did not exclude her evidence. You can read these quotes. So that's it. That's opinion evidence. I hope you had a good time. I sure the heck did. I'll see you soon to talk about identification evidence.